Good afternoon, everyone. My name is Kathy Purdy. I am the marketing manager at Schoeneck King. I'd like to welcome you to this week's coronavirus update and discussion on continuing legal and practical issues related to COVID-19. Two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and our presenters will get to those as time allows before the webinar concludes. Once the webinar has ended, if you would just take a moment to complete the brief survey, we would greatly appreciate that. So to start this week's presentation, I'm going to turn it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's a beautiful summer day outside. I know the unofficial end of summer was yesterday, but I'm going to prefer to go with the calendar version here. So hopefully we've got a few more weeks of summer weather and summer to enjoy. We've got a full program today. I want to start off. We're going to start with Erica Wood. Erica is a tax practitioner in our Albany office, and she's going to walk us through a number of the questions that have arisen with the payroll tax guidance, and frankly, what are your options? So Erica, please take it away.
Yeah, thank you. Nothing like ending Labor Day weekend by talking about payroll taxes, but we'll try to make this as painless as possible for you. So as an update to last week, or maybe it was 2 weeks ago now, when you heard from my colleague Jessica, who gave you an update on the executive memo that had been issued by the president on August 8th. So that executive memo had left open a lot of questions about this payroll tax deferral for the employee portion of Social Security, which is 6.2% of their paycheck. So a lot of the questions, and the most important being, well, is this program optional or mandatory for employers to participate? Do they have to pay back the payroll taxes at any point? If they do, what's the timing of that? Those were some of the key questions that were left open with the executive memo. So the IRS or Treasury issued on August 28th, Notice 2020-65. Again, this notice left some things uncertain for a lot of you. It was a very quick 2-page guidance. And unfortunately, in that guidance, they never explicitly said whether it was optional or mandatory. Us tax nerds, did a little digging into the underlying guidance for the notice and the Internal Revenue Code section that's actually referenced within the guidance, and the fact that the affected taxpayer for purposes of this notice were employers. So that's the target audience here, and ultimately who's liable if the tax isn't paid. So that was really the biggest question, was, is it optional or mandatory to participate in this program? We'll get into some of the details after we kind of answer this question, because I think it's the most important. And some people might stop listening after I tell you it's optional, which it is. We're certain it's optional. Not only did the notice make it clear that it was optional because of the underlying guidance, not because the notice itself was very clear, as I said. However, IRS, I think, realizing that people were very confused with the notice, came out on September 3rd and explicitly announced that this payroll withholding is an optional program for employers. So that's the most important takeaway here. You as an employer have the choice to participate in the program. So what is this program for anyone who needs a refresher? Essentially, from September 1st until December 31st of this year, it allowed employers to not withhold the employee's portion of Social Security tax from their paycheck. So that would mean an extra 6.2% in certain employees' paychecks. These are employees who are making less than $4,000, so less than. So if they're equal to $4,000, then they're out of the program. So it's less than $4,000 on a biweekly basis, and this is on a pre-tax basis as well. One of the key issues that came up in the notice is that employers need to test. So if you have fluctuations with your employee salary for whatever reason, it's up to you and it's your obligation to determine whether your employees are eligible every biweekly period. So that's going to create, for some of you, some administrative issues. Another issue that came up, so this is is how you're gonna, make this program. Can you offer it to some of your employees, or do you have to offer it to all of your employees? So if you have those eligible employees, so they're making less than that threshold amount, you as the employer could choose, you could give the option to your employees as to whether to participate. But again, in addition to this testing for the $4,000 amount, you might be walking into just some administrative payroll issues. Who runs your payroll? Do you do it internally? Do you have a third party do it? Do they have the ability to make it apply only to some of your employees and not to others? Because ultimately, at the end of the day, in addition to the important takeaway that it's optional, should you participate, a really important takeaway is that the employer is ultimately liable. So if for whatever reason, these payroll taxes, which will be paid back, at least as of now, and we can talk about that a little bit in a few minutes, these payroll taxes will be paid back between January and April of next year, ratably. So you can basically, you're going to be double withholding on the employees that participated in the program. But say you're an employer and an employee who you didn't withhold on leaves your employment. The IRS has made it clear that you as the employer are ultimately liable for the tax. So for whatever reason, it really doesn't matter. The tax must be paid and it needs to be paid by you. And you're going to need to deposit in accordance with your normal schedule. So this has raised a few different questions. One is there's been a little bit of a disconnect, I think, between employers and employees. This is because headlines are kind of making this payroll tax a very attractive option. You're going to have more money in your paycheck. Here, you're going to have excess cash flow. Your employer really, they need to participate. And since you're the employer, or I'm presuming I'm speaking to some employers, you're going to be on the hook ultimately for paying this tax back. That creates some issues and some risk management. So there comes up a question, should you have your employees enter into an agreement that say they're gonna leave? You have the ability to take that additional payroll tax before they depart your employment. Important that you consider that depending on which states you're operating, that may not be permissible under state law. If you have any collective bargaining or union agreements with your employees, that also might be an issue there. So those are things you're going to have to consult with your attorney on to make sure that if you are going down that route of considering participating and having an agreement as a backstop, that you're making sure you're complying with the law and that it's ultimately enforceable. Another issue is when this money comes to become due, and this might help in terms of presentation. So say you're an employer and you don't want to participate in the program, which my experience has been that many employers are opting out. Your employees come to you dissatisfied because you're not giving them this benefit. They're getting, they should have this ability to get this more money now. A lot of people are in need of money. Something that might help in terms of presenting it is to show them that the money is going to be paid back. And so ultimately, come December 31st, so starting in January, their paychecks are going to see double withholding for payroll taxes. So for Social Security, instead of the traditional 6.2, they're going to have 12.4% plus the employer portion that's always been coming out. So they are going to see a ding in their paycheck, and this is going to come at a time where we're post-holidays. A lot of people are, paying back their credit cards or catching up on the extra gifts they gave to people. And so that's something to consider, that is the time value that important that they really want to have to pay back that extra money later? There's been a lot of question about whether this payroll tax is going to be ultimately forgiven, and so are you as an employer who's not participating doing a disservice to your employees? Unfortunately, that's just a question of politics that we can't predict. Ultimately, right now, our best judgment can show us that it's probably unlikely it's going to be forgiven. I mean, again, we can't predict politics. We have no idea what's going to happen. That ultimately is a question for Congress. But based off of the underfunding of Social Security and just the fact that ultimately this is unlikely to pass in the House, I wouldn't necessarily count on that as a reason to participate in the program. So again, to just kind of wrap up what we've talked about, this is an optional program. So employers have the option to participate. You have no obligation to really communicate with your employees about why you're choosing to participate or not, although for different reasons and for purposes of keeping a good rapport with your employees, you might choose to have that conversation. Something important to emphasize is the fact that the money will be paid back and the timing of when it's going to be paid back, talking that through with them, and then again, considering, well, if you are going to participate as an employer, is it worthwhile to enter into some sort of agreement? Again, making sure we're doing the double check of, is this in compliance with state law? Is this in compliance with any underlying agreements I have with a labor union or in a collective bargaining agreement? So I know that this created a lot of confusion for people. Hopefully this helps to clarify and answer some of those questions. But ultimately, it is a program that I don't expect to see a lot of participation in because of the risk to employer and because of the timing of the payback and the fact that ultimately, at least as of now, that amount will need to be paid back. So that's really all I have on payroll taxes. I think we'll move on to probably some more exciting topics today, but I think people did want to hear an update on this, and the fact that it's an optional program, I think, is the most important takeaway here.
Thanks, Erica. Real quick, some people are asking about the notice requirements, and I think I understood you to say that, you don't need to communicate because this is optional. You don't need to communicate, but you also raised a very important issue, which is, should you be communicating in the sense that, it's good employee relations. And so whatever you decide to do, do you want to, communicate that out and be clear about what you're doing and why? So I think that's probably a second level question that's a little bit, it requires some thinking and some analysis once people decide what they're going to do.
Yeah, I agree. I think it's nuanced and really dependent on the employer and their employee base. And, I've spoken to some clients who have taken the approach of, communicating it in a certain way because they've had a lot of inquiries about the program. And then others that really are going to just go ahead business as usual. So I really think it's specific to, that particular employer.
Okay, great. Thank you. Thanks for the update on that. Another topic that we've been getting a lot of questions on, and frankly, I think another source of considerable frustration is the unemployment, really the issue of unemployment, and a lot of questions around, the expiration of the supplemental benefits and what the future may hold, and some of the other elements of the CARES Act. So we're going to have Paul Bueller, who's been following these developments very closely, give us a little update on some of the things that are really on everyone's mind, because we're getting these questions repeatedly. Paul, take it away.
Thanks, Pete. So hopefully this one, I don't know if it's more interesting than Erica's topic, but hopefully we'll learn something. So first, I just want to give everybody kind of a baseline reminder where we are in terms of unemployment. We've talked about this a few times on the webinar, but basically there's three categories of unemployment. There's the normal eligibility that always exists, and then there's two additional categories that were created under the CARES Act. One is for individuals who aren't typically eligible for unemployment benefits. So that's people who, their benefits have expired, people who are self-employed, independent contractors and the like. And those people are able to receive unemployment benefits if they have a certain COVID-related qualifying reason that prevents them from being able to work. So this is people who have been diagnosed, people who are caring for a family member who's been diagnosed, people who are subject to some sort of order of quarantine, people who have, they received an offer of employment that's been rescinded due to COVID. They're not able to travel to their job due to some sort of travel restriction, those sorts of things. So those people can get the typical unemployment benefits, but it's all charged to the federal government rather than to New York State. And then the third category is effectively just an extension of the normal unemployment benefits that allows everybody an additional 13 weeks of unemployment benefits. So they can use a total of 39 rather than the normal 26. These two additional categories that were created by the CARES Act expire on December 27th. So, fresh start 2021, people will only be able to collect unemployment benefits under the normal eligibility criteria. That will hopefully calm things down for all of us. A couple of other new developments. In August, President Trump signed an executive order that basically allocated a little bit of additional money. We know that the $600 enhanced benefit expired at the end of July. So Trump signed an executive order in early August that allocated, instead of the additional $600, now people can get an additional $300 per week in unemployment benefits, with a couple of caveats. First, you have to be receiving a baseline of $100 in normal unemployment benefits from your state. That will get you eligible for the additional $300. So it doesn't matter which category of unemployment benefits you fall into, whether it's the normal eligibility criteria, whether it's one of the two enhanced criteria created under the CARES Act, you'll get this additional $300. This money is all coming out of FEMA's disaster relief fund. So they basically said, we've got $44 billion, and once that's expended, it's gone. So to kind of put that number in perspective for you all, this money is going to go retroactive to August 1st. Some people may have already seen this in their unemployment checks, but I think a lot of people are going to get basically one large check for this additional benefit. In terms of the dollar amount and how long this will last. So we saw with the additional $600 that everyone was receiving, starting in March all the way through the end of July, month to month, it cost the federal government around $80 billion. So this is now $300 a week instead of $600. And they basically said that we expect this to last 5 to 6 weeks. So this additional $300 benefit is probably going to expire sometime over the next week, maybe two, depending on the number of people that are actually receiving it. And like I said, you've got to have a baseline $100 benefit from your state to get this extra $300. The next kind of important thing, and this is what I really wanted to focus on, this is critical for you guys that are self-insured nonprofits, self-insured government agencies, so school districts, state workers, that sort of thing, and then also self-insured Native American tribes. So I think we've got a slide here. There's a notice, if we could just pull that up, that all self-insured, for unemployment purposes, all self-insured employers should have received this from the Department of Labor sometime over the last few weeks, probably with your second quarter charge statement. And I think this has created a lot of confusion because it goes into this 50% reimbursement for self-insured nonprofits, governmental agencies, Native American tribes, but it doesn't really explain how that reimbursement is going to work. So again, there was an act that passed Congress, President Trump signed into law in mid-July, called the Protecting Nonprofits from Catastrophic Cash Flow Strain Act. And what it basically did was explain how this 50% reimbursement is going to work. We initially thought that there were sort of two options for how this could work. First, your state could charge all self-insured nonprofits for 100% of the unemployment benefits they pay out, and you'd get a 50% reimbursement later. The alternative was that New York State, for example, could charge self-insured nonprofits 50% and then wait for the other 50% to come from the federal government. We saw that basically every state across the United States, New York included, went with option one. They charged all these self-insured nonprofits 100% and said, we'll get you the other 50% later. And we saw that that put a lot of strain on nonprofits because you're paying out dollar for dollar every benefit that gets paid out in unemployment insurance. The DOL had basically halted their process for contesting claims. And so they were just approving claims over and over and over again, and the bills were racking up. So Congress passed this Protecting Nonprofits from Catastrophic Cash Flow Strain Act, and it basically said, from this point forward, you can only charge nonprofits for 50%, and you're going to wait and get the other 50% from the federal government later. It didn't apply to any benefits that had previously been charged to you guys, to you self-insured nonprofits, but moving forward, you could only be charged for 50%. So to respond to this, the New York State Department of Labor basically issued this notice that we've got up on the screen here. And again, I think it's very confusing. It doesn't really explain what's going to happen next. And I've been in contact with a couple of people at the DOL. They basically explained this to me that, you know, the New York DOL wasn't able to update their system quickly enough to reflect that they could only charge, you know, these self-insured employers 50%. So they tried to include this notice and explain you're going to get your reimbursement, but they didn't explain how. So we've reached out, and effectively every self-insured employer who reaches out to the DOL, and we've been doing this on behalf of a lot of employers, explains their situation. The DOL has said, you can just pay 50% of your most recent charge statement. We'll accept that. I don't recommend that any of you guys just take your bill and pay 50%. I absolutely recommend that you reach out to the DOL. This is something that we're doing on behalf of a lot of employers. We've never once been turned down so far. But you have to open that dialogue with DOL and explain to them, you know, we understand that we should only be charged 50%. And like I said, we've had a 100% success rate with the DOL explaining, yes, okay, you can pay 50%. And then we've been, you know, in contact with them while employers are providing their payment to ensure that they understand they're only getting 50% now. They're going to get the other 50% from the federal government. And that's really important because if you don't pay the amount that your charge statement shows under normal circumstances, they can charge interest every month, compounds every 30 days. They can charge fines, and we've also seen that they charge corporate officers with misdemeanors for not paying the the amount of your charge statement. So it's critical. Moving forward, these self-insured nonprofits should only have to pay 50%. Absolutely open a dialogue with DOL first. Confirm that you can only pay 50% moving forward, what your charge statement amount is. That way you can avoid these fines and interest and penalties and the like for not paying what your actual charge statement is. Like I said, we've been in constant contact with DOL about this particular issue. And like I said, we've been able to confirm with them on behalf of individual clients that it's acceptable to just pay 50% moving forward. So that's my my unemployment update. We can move on to whoever's next.
Thank you, Paul. That's very helpful. And I think good advice in there. If you're in that circumstance, you could get some relief here. Probably self-help's not the best option. Reaching out is, but it looks like you may be able to help with the cash crunch there. All right, we're going to turn to Katie Anderson. I think I've had 3 emails from Katie since we logged on 5 minutes before this webinar, so I suspect there's a lot going on today as well as generally. Katie, take it away.
Yeah, that's true. In classic Governor Cuomo fashion, he decided to give an 11:30 press conference. Don't be sad. I will tell you everything that happened because I had that going at the same time as the webinar. So first thing, this is an old map. The governor just announced that the following states were added to the travel advisory: Delaware, Maryland, Ohio, and West Virginia. Again, added to the travel advisory, you have Delaware, Maryland, Ohio, West Virginia. Removed, Puerto Rico, and the U.S. Virgin Islands. So no states removed, but again, I'll just repeat it one more time. Delaware, Maryland, Ohio, West Virginia, all added today. You know, one of the biggest thing that the governor touched on today is it's after Labor Day. We are entering a new phase, he called it. He said we're entering the post-Labor Day phase. And what does that mean? We're seeing a rise in activities. People are going back to school. You have colleges out there, you have K through 12. People are, you know, going into the office more. You're seeing traffic increase. All of these things. You're also seeing flu season. It's really going to be a test over the next 2 weeks to see how we did over Labor Day weekend. Were there gatherings where COVID was spreading? It's going to be a major test. And one thing that's really going to be important is that today the governor is the Department of Health is issuing regulations regarding colleges. So these regulations it's going to say, supposedly, that colleges must report when there are 100 COVID cases. So I don't know if that means daily. I don't know if that means total, to the Department of Health. Once it's reported to the Department of Health may decide to shut it down, or not shut it down, fully move to remote learning for the remainder of the semester. That is very different from the guidance I went over with all of you last week. That's a big shift, and we don't know that much right now because we only know what the governor said, and what he says at press conferences tends to be significantly different from what's actually written in the regulations. But those will come out today, so I'm sure that will be circulated to those who need to know. One other thing, too, that the governor went over today is it's about New York City restaurants. As some of you may know, there's currently this $2 billion class action that's been filed against New York State and New York City for no indoor dining. And really, the governor went through a list of reasons why New York City indoor dining can't open, but the main thing hinges on local enforcement, saying that they need health inspectors, New York City health inspectors or police to go in and enforce these gathering, mask wearing, all of those restrictions we're all very familiar with at this point. So those are the biggest updates. One final update from the governor today is we have reached in New York, we've reached 1 month with below a 1% infection rate. Coming from March or April, that's enormous. So it's quite an accomplishment. Yesterday, the governor signed legislation that will require public employers to plan for future pandemics. So public employers, that's state and local governments, that will include school districts. This plan has to include a list and description of essential workers, plans for how telework will happen or staggered work shifts, how you will be able to get PPE, and plans for exposure. So if somebody is exposed, what are you going to do to isolate them and isolate those who have been, in close contact? Those plans must be submitted to the union or labor management within 150 days. And the plans must be finalized by April 1st, 2021. So that's a big shift. Once we are able to dig a little bit more into this legislation, we will, get that out to all of you with more information. That is, the final updates are updates that came about on Thursday. Thursday, the governor announced that as of tomorrow, we are going to see casinos and New York City indoor malls reopening. For casinos, you don't have floor service. They will have no live performances. Again, no performances cannot occur in New York right now. There will be a 25% occupancy limitation. 6 feet of distance must be maintained. Masks must be worn. All of those things we're all very familiar with at this point. And finally, tomorrow is the first day of school for many people, many students. I hope for everybody it goes well. I know that it's very stressful for everyone involved, from parents to teachers to students to administrators. Everybody is stressed about this one. So good luck, and we will be cheering you on and thinking about you. And of course, let us know if we can do anything to help. With that, Pete, I am done.
Thank you, Katie. And we're going to hear from Kate Reed in just a minute. But before we do it on the school reopening issue, but before we do that, we're going to check in with Teresa. Teresa Rusnick is in our Rochester office. We've been hosting a series of webinars on New York paid sick leave, and they're, not strictly speaking directly COVID related, but it certainly is a hot topic and one of interest. So Teresa's going to go through some of the very frequently asked questions that we're getting and give you some insight. Teresa, take it away.
Thanks, Pete. So as Pete said, I will be going over some of the New York State paid sick leave questions. I actually pulled questions that you all submitted during our last Tuesday webinar. So everything I'm going to be answering in the next couple minutes are actual questions that you all have asked. And there's certainly some things that I've seen as a common thread. So without further ado, I'm just going to jump into our first question, and it's one I get asked a lot, which is, can you have PSL accrue for some employees and front load it for others? The answer to that is yes. Just please be mindful that you can't have certain employees getting a lot more PSL than others based on their race or gender or age or any other type of protected category. But generally speaking, if you want to have accruals for non-exempt employees and front loading for exempt employees, there's nothing in the law to stop you from doing that. Another question I got after last week's presentation is, how does New York paid sick leave dovetail or work with New York State paid family leave? This is one where we're very much still waiting on more information from New York State before I can give you any sort of definitive answer. I do think that we will see that New York State paid sick leave can be taken to supplement paid family leave and bring an employee's wages up to 100% at the employee's choice. I can't confirm that though, because that is something that will be hopefully addressed in the guidance. Another question I got, and I've been getting this one a lot, is how do we handle the medical certification requirements in light of the fact that the statute says you can't require the disclosure of confidential medical information before granting someone's paid sick leave? The question I get the most is, and I understand why, is if we have someone out for 3 days on paid sick leave, can we require medical documentation of their illness? And I know that question comes up a lot because that's in a lot of employers' current policies, and it is allowed under the New York City Paid Sick and Safe Time Act, which this law is obviously very closely modeled after. I can't say for sure whether or not that's going to be allowed for New York State paid sick leave. We simply don't know. The law does not define what confidential medical information is, so we don't know if that's going to be a very narrow definition or a very broad one, or what type of medical certification can be required on the basis of that. But certainly that's something that we would hope to see addressed in the guidance. Coming off of that question is, what about a return to work note? If someone's out on paid sick leave, can we require that they submit a return to work note? Generally, when someone is out on paid sick leave, you can require that, but again, I don't know the specifics for New York State paid sick leave because we're still waiting on the guidance. One question I got a lot is, can a plan which offers more than 40 hours of PTO meet the needs of the PSL requirement, or does PSL have to be separately tracked? So basically, if you allow for 40 or more hours of paid sick leave and you have between 5 and 99 employees, do you have to allow paid sick leave separately, or can it be part of your PTO policy? It absolutely can be made part of your PTO policy, as long as you meet the use, carryover, and accrual standards for paid sick leave that's laid out in the statute itself. You don't need to give more leave than the statute requires if you're already giving it as a form of PTO. Just make sure you're clear on altering your PTO policy to meet the requirements of paid sick leave. A question I get, are nonprofits required to comply with New York State paid sick leave? And I think this is because public employers are not required to comply with paid sick leave. Nonprofits think there may also be an exemption for them or an exemption for religious institutions. That is not the case, or it's at least not the case as we're aware of as right now. The definition of employer under New York paid sick leave is very, very broad. And unless the guidance limits it farther, I think we're looking at that applying as a very broad definition into essentially every type of employer except for a public employer. How does paid sick leave work with employees in other states? Or some variation of that question is one I get a lot as well. If we have employees who work for a New York company but are in a different state, or conversely, if we have employees that work for a non-New York company but are in New York State, do they have to be given paid sick leave? I think in the second scenario, the answer is most likely yes. If they are sitting in New York and they're working in New York, even if they're working for a company that's headquartered elsewhere, they are going to need to be given paid sick leave. As for whether or not paid sick leave needs to be extended to, employees working in other states for a New York company, certainly the conservative answer there would be yes, to extend the leave to them, but it's not something that we have a concrete answer on yet. Another question I get is, how do we track paid sick leave for exempt employees? How do we know how many hours a week they're working if we're using the accrual method, if they're exempt employees and we're not used to tracking them? There's no easy answer to that either. I would invite you to consider how you're tracking the hours for your non-exempt employees and see if that could perhaps work for your exempt employees as well. You could also, for your exempt employees, if you want to avoid this hours tracking issue, just front load the leave, which I've seen a number of employers do as well. But bottom line, if you are going to be accruing the leave for your exempt employees, you need to figure out a way to track their hours so that you can make sure they're accruing the leave at the rate of 1 hour for every 30 hours worked. That requirement doesn't go away just because they're exempt employees. Now, it's possible that when the guidance comes out, New York State could say something like, we assume for purposes of paid sick leave that exempt employees work 40 hours a week, and that's what you can use for accrual. It is very possible for the guidance to say something like that. Certain guidance does do that for exempt employees in other contexts, but again, we don't have that yet. And then finally, and I think this goes nicely into Kate's part of the presentation because it involves students, do interns and students count as employees for paid sick leave? And the answer is, if they are issued a W-2, they very likely do count as employees for paid sick leave purposes. Much like the definition of employer, the definition of employee is extremely broad under the New York paid sick leave laws. So if you are issuing a W-2 form to this individual, or should be if they're an unpaid intern, they very likely are going to be able to accrue or be front-loaded paid sick leave. So those are some of the questions I get the most. Again, those were all ones that were submitted by you all last week, which I thank you very much for that. And now keep them coming. Pete, back to you.
Teresa, thanks. I think this is just a very difficult exercise for everybody because we've got statutory language that we are very close to having to implement, and we don't have guidance. And as with any new statute, there's a lot of questions that arise. So the folks on this call have been dealing with this, uncertainty and the difficulty in trying to interpret new requirements and, the changing landscape for the last 6 months, with the pandemic. So this is just another one of those challenges, but we're getting there. We'll work through it and hopefully we'll get some guidance soon that'll help. With that, let's turn to Kate Reed. Kate has been following the school reopening guidance, which is of interest across many dimensions for our clients and our friends. So Kate, take it away.
Sure. So talk about shifting mandates and constantly evolving requirements. Schools have certainly been an area where we've seen a lot of change, a lot of regulatory activity, and a lot of activity from the governor. And I think it is really forefront on everyone's mind because, as Katie mentioned, we're now post-Labor Day. We're in the governor's new post-Labor Day world, and presumably this is the time of year when in prior years kids would be going back to school. So school is looking a little bit different this year. I'm going to recap a little bit of what we spoke about in prior webinars, but essentially school districts are still required to follow essentially two guidance documents, one promulgated by the State Department of Health and one promulgated by the New York State Department of Education. So schools are regulated via both agencies. And one of the fun things about being a school attorney, as I am, is that those requirements in the two guidance documents don't always overlap perfectly, which is where we get lots of fascinating questions. But essentially, when there are inconsistencies between the DOH guidance and the SED guidance, the DOH guidance controls because the Department of Health controls all health-related decisions. So school districts under both requirements and both regulatory schemes were required to put together reopening plans that will be rolled out this week as students are returning to school. We're seeing a wide variety of plans throughout the state. I think initially when the guidance was rolled out, there was an expectation that some degree of in-person instruction would be delivered in all districts throughout the state. And we're seeing that that's really not the case. Districts are in very different positions with respect to the reopening issue. We're seeing some districts that are back to full out instruction in person, some that are delaying their in-person instruction for a few more weeks until they can be sure that they're in compliance with the guidelines, and others that are doing the so-called hybrid method where some students will be in person on some days and at home on other days. And a lot of that is being driven by factors that are beyond school districts' control, such as their fiscal condition, how much money they have to implement things like PPE, appropriate social distancing, sanitation measures, etc. A lot of it has to do with their physical facility and plant. So schools were not anticipating, having to respond to all these safety concerns up until very recently. And the process of having your facilities be used for a different purpose than what they were originally approved by is a very complicated procedure under New York state law. And those requirements have to be approved by the New York State Department of Education. So those also culture, risk tolerance, there's a difference still in the infection rates between downstate versus upstate, major metropolitan areas and more rural areas. So those factors are influencing districts' risk tolerance and comfort with in-person instruction. So, but the big picture issue here, and it's a recent update, is that the governor did issue an executive order on Friday that formally closed the school closure order. So beginning on March 7th, 2020, schools in New York State have been formally closed by order of the governor, by executive order. And on Friday, the governor lifted that closure order and stated that schools are no longer closed per se. They may open to the extent that they do so consistent with the DOH guidance. So that's where the rubber meets the roads for a lot of schools, where they are able to reopen under the governor's executive order, but they may not be able to comply in full with all of the very stringent and onerous requirements under the Department of Health guidance. So schools may open. One of the things that the governor also said in that executive order is that if schools are reopening, they also have to have contingency plans for how they will ensure the provision of childcare and the provision of meals to students in the event that schools close in the future. As we saw through this pandemic, schools are not just important for educating students, but also for feeding students, providing very valid and important childcare purpose in our society. So the governor wants to ensure that if there's a future school closure order, those items will not be lost in the fray, and that we will have plans in place for how to provide meal continuity and childcare continuity. Another major development last week was the governor in a press conference announced that schools will be responsible for making regular updates to the State Department of Health regarding their COVID-19 numbers. There's going to be the creation of a quote unquote dashboard where the public can tune in and essentially see how a school is doing with respect to positive cases of COVID-19. This caused a little bit of a panic among all of our school clients last week, insofar as those of you who've been tuning in for the last few weeks may recall that I actually reported a few weeks ago that schools are not themselves authorized to conduct COVID-19 testing. They're required to obtain special licensure through the Department of Health, and to my knowledge, the only district in the state that is actually authorized to do that at this time is the New York City Department of Education. So schools, by and large, across the state are not testing. That is consistent with not only the DOH and SED guidance, but also with CDC recommendations that schools not serve as actual testing facilities, but rather serve as a liaison with other testing agencies to ensure that kids can get tested and families can get tested as necessary. So imagine the surprise of many schools when they hear the governor say last Thursday, you're going to have to upload your testing results to this dashboard and portal organized through DOH. So what I can say at this point is we do not have an executive order, to my knowledge, that has codified what it is the governor meant exactly by that. But he did announce during today's press conference that information that will have to be reported to the state includes number of COVID-19 positive cases and such. Once again, a little bit curious, because one of the things that immediately happens in my experience as a school attorney is that if there is a positive case with respect to a staff member or a student who's enrolled at a school, it's usually the DOH that's informing the school of that positive test and not in the other direction. Given that 99% of school districts are not going to be doing their own testing, it's likely that the first notice that they will have that somebody is tested positive is actually in the form of a communication from DOH. So once again, a little curious that we'd be uploading or updating DOH about that. Also interesting, of course, is the fact that the State Education Department and Department of Health guidance contains fairly detailed guidelines around when and how various school buildings should close. An early question that emerged when the school guidance came out was, if there is a positive case in a school district system, is the entire system required to close? Or can we just close, for instance, a particular wing of a building or a building itself or a grade level? And the guidance is very flexible. It envisions that in some circumstances, an entire school system would not shut down merely as the result of a single COVID test. Likewise, a whole school building in all cases may not shut down if, in the judgment of the Department of Health, there was a minimal exposure from that contamination and various other factors. So it will be interesting to see how this dashboard plays out in terms of, public relations between the public and schools, parents and schools, and other stakeholders. Of course, if parents can be monitoring COVID tests and seeing that that a person in a school system has tested positive, I'm envisioning that that is going to put tremendous pressure on schools to respond and potentially close down at a greater rate than what might be strictly mandated by the Department of Health guidance. So those are the big developments last week. Another development that is less timely, but I believe we provided an update about this last week, but it's certainly proving to be very difficult to navigate in the school context, is the issue regarding intermittent leave. So as we reported last week, the Department of Labor guidelines and question and answer has been updated now to reflect the recent Southern District of New York decision regarding the use of intermittent leave for families that are on some version of either remote instruction or hybrid instruction. So as I've previously reported, the school guidance allows school districts to do hybrid instruction or fully remote instruction for that matter if they can't comply with the Department of Health guidelines. So the question has emerged of, what if you are a parent whose child is in attendance on Monday, Wednesday, Friday in person, but then participating remotely on Tuesdays and Thursdays? And the DOL guidance has now clarified that an individual whose child is on remote instruction and therefore not physically present in a school building on a particular day, that school would be deemed to be closed for purposes of intermittent leave under the EFMLA. So this is going to be complicated to implement, not only for schools, of course, but also for all employers. Because if you are an employer, you likely employ people who have children that are enrolled in schools. And in most instances, many schools that may not be coordinated. As I said, the option of remote versus hybrid versus in-person is very much a local decision over which local schools have control. So that being the case, you could be an employer who has employees that have children enrolled in many neighboring school districts. And all those schedules will now have to be balanced. So this is, it's going to be difficult, as I said, for schools, but more importantly, I think for all employers to navigate as we move forward with the school year. So that's about all that's new on the school front. I'll turn it back to Pete.
Kate, thank you. And I think that'll do it for us today. We're right about up against our time. So thanks everyone for being with us again this week and every week. And we'll keep doing this for the foreseeable future. There's just so much going on. This seems to be a good mechanism to get the information out there. So take care this week and we'll talk to you next week.